and Word format. Then we have our CodeX affiliated faculty, Thibaut Schreppel, who will give us an update on the progress of the CodeX computational antitrust project. And then we have Mitch Spira, who's an old friend of our center, or I shouldn't say old, he's a young friend of our center, but he's been a friend for a long time. He's the VP of product at InCloud Council, who will tell us a little bit about InCloud Council. So with that brief introduction, just wanted to tell our speakers that we have an hour typically for this meeting. So that would leave 20 minutes to each of you. And I would hope that you could give a brief presentation, but also leave time for discussion with folks in the audience. And before I turn it over to Nabha, I wanted to see if anyone in the group wanted to share any news or had any updates for the group. If so, please speak up or use the chat function as Lance just did, who is sharing with us that Harvard University, that other university on the East Coast, will be publishing his latest research paper. And I'm not sure, is it an AI and law related paper, or what's the topic? Yeah, well, thanks, Lance. And so if anyone else has anything to share, please do so. And I will turn it over to Nabha, if you're there. Hello.
Hello, Roland. Can you hear me?
There you are. Okay, over to you, Nabha.
Thank you. I'm just sharing my screen. Please let me know if you can see it.
Yes, we can.
Thank you, everyone. So I'm Nabha Kwaja. I'm a lawyer, a legal tech entrepreneur, and a writer. And I'm very interested in law and technology. And I'm currently working at the intersection of the two. So I've been exploring legal tech from a very long time. And I have been founding some companies to organize events and to spread awareness about the same. Now, this is my project ORMS, Automated Forms. So ORMS have been derived from Automated Plus Forms, which stands for ORMS. And so the background is that, as we know, this is the era of automation, and like online forms and document automation, these terms are no more an alien term for many. Whenever someone needs to fill a PDF or Word form online or to sign the same, one prefers to take a printout of it, and after manually filling it and signing the same, they scan it and upload it on the computers. So it is very hectic and complicated. Now, how did I get this idea? So I established an NGO last year called Be Foundation. Be stands for Be a Beautiful Person. So when I was publicizing my NGO on social media, many acquaintances and even strangers reached out to me, expressing their interest in joining my NGO as a member. So I asked them for the email IDs and sent out membership forms, which were in Word format, and then asked them for basic details and signatures on those forms. Now, however, I never received those filled in forms back and with their signatures. And when I contacted a few of them to ask why haven't they sent them through, they told me that they were facing trouble filling it in, and they do not want to. They also do not want to, take out the printouts. They were just not willing to pay that many efforts, and they also had no idea how to affix a signature on it without taking out a printout. So eventually I felt that maybe I should have sent them a simple form or one that didn't require signatures, or maybe should have guided them how to affix signatures on the docs. But then I thought that to how many people will I teach this? And they were not illiterate. They were not illiterate. One was a doctor and the others received education from the top schools and colleges of the city. But having quality education doesn't mean having tech skills, right? So I also wondered about the very many people around the world who are like my aspirant NGO members, had no idea how to fill in PDF or Word forms without resorting to a printout. And more printouts means more allocation of time to a task which can otherwise be done very quickly and efficiently. And it also requires spending of money uselessly, and also calls for more usage of paper, leading to environmental concerns, like we all know. So I thought and thought and thought. Then I did some research. What I did, that was very basic research, like searching online for document automation software, playing around platforms like Google Forms, Typeforms, etc. And then I searched for technologies which are currently automating text. So what did I find? So current procedure to automate document and forms are that various no-code platforms and low-code platforms are out there, and there are a lot, like Automation Anywhere, Typeform, and they are being used to automate documents currently. So how it is being done now? First, a person comes in, uploads a form or a document, then he himself adds questions, add variables, upload original document, and then tag questions. So it is currently quite complex. And if a person is not tech savvy, they can't really do it. So now this is the current procedure. I just did a little drawing that you have to fill in the question, you have to add a variable, you have to choose a question type, edit it, add logic on your own, and then to setting it as per your own requirement. Now, tagging question, that is a very complicated part in which we have to tag questions. And sometimes, if there are a lot of questions, we forget which question was tagged to which question. So, like you can see over here on my screen, this is the question one, name of the question. And then on this part, we have to add tag the previous question, which we added in the questions page. And then similarly, if you have to add logic questions, then also the process is quite complex. So what is ORMS? ORMS is basically a B2B product and a SaaS platform, and we ORMS propose to present a solution which can automate forms and documents with minimal human interference and efforts, and can be used by even people possessing minimum tech skills. So anyone can do it. Now, the process which ORMS involves will be an online platform where forms can be uploaded to get automated. The technology recognizes the questions and variables of a form and automate them, and then it gets converted into guided interviews and can be accessed and filled on a platform by our users, customers. Now, this is a sample of a form where if you see the highlighted part in red, so this is what the technology will do, not us humans. So the technology will recognize the questions and the variables, like it has recognized the question over here, which involves a yes no question, and above the variable part, and then it will go on to tagging the questions. It will, this is before recognizing variables, and this is the image after it recognizes the variables. So we do not have to do anything. It will be recognizing all the variables. And then if I get onto the use case, so what it will do, consider a person Mark, who is the managing director of an XYZ law firm. He wants to get his original PDF automated and converted into guided interview forms for his clients. Now, he wants to do it because he wants to avoid complexity and to serve customers who are not tech savvy. So the preconditions are an original, which will require an original PDF or Word form, and the post conditions are that a form in the format of guided interviews with help text will be there to guide the customers at every step while filling in the form. Now, the main success scenario will be that user uploads a PDF form on our website. Our technology automates it, converts it into a guided interview form on our website, and then the customer can fill, our users, customers can fill in those forms, and then the answers get filled in on in the original form. That is the form which was there before getting automated. So the our user will receive all the information in the original format. And if there is a, so if I move on to the extensions part, then the probable error is that sometimes the technology might fail to identify the variables or questions due to perhaps the structure or type, and therefore might skip to include them in the skip questions. But it will be very rarely, and the user, and if such case happens, the user can just pick those questions and drag and drop those into his guided interview complete form. Now, this a platform has to be used for every new form which has to be automated, and then a subscription fee has to be paid constantly as the forms and guided interviews will be hosted on our server and also be filled there. So our users are law firms, corporates, businesses, banks and other institutions, colleges, universities, schools, hospitals, etc. And our business model includes that we will be charging a subscription fee on a monthly basis by providing user accounts. And we aim to earn from blogs and SEO services. Now we want to charge per user account, but also we want to post plans because often I've come across that sometimes people or individuals do not want to use a user account because they're quite costly and they just want to do uh, like whenever they have a form to automate. So maybe we will post a plan for an individual account and charge on a per time use basis. Then we seek to gather funds through crowdfunding and to get in touch with investors. So this is all about it. Alhamdulillah, and thank you for having me here. I know it's not a big presentation, but this is the gist of it.
Thank you, Nabia. This is very cool, and it's interesting that that you haven't listed the government as a potential customer. It's probably one of the places with the most forms in use in the world, but maybe the least desire to make him easy. But I don't know.
Thank you, Roland. I think this will really be helpful. That's what I came to Codex for. I knew I would get such a good suggestion.
So are you okay? So you're basically reverse engineering these forms, and then you automatically help create sort of a questionnaire based on the form, and then the information that people submit is then stored again in the original form and then submitted to the eventual user. Okay, very cool. And in how far along are you at this point? Are you? Yeah, I think you said you're looking for investors at this point, or do you have a prototype already working, or is this still in the idea phase? Or?
Yeah, actually, I have a developer working on the technology, and I'm working along with him. I do not have a big team right now, but we are currently working on the technology, and our next step is actually connecting with the investors.
Okay, got it. Okay, folks. So let's see. Do you guys have any questions for Nabia? You can go ahead, please. Yeah.
Yeah, I just want to add on a side note that if you visit her city, is famous for some of the food called tunde kebab. Don't miss that.
I think they can also use my forms.
This is Aftab. Yeah, certainly a great idea, and I like it, especially for developing countries, and not only developing countries, but sometimes even it will be a very good tool for developed countries, making things simple for common people. Certainly, I appreciated the idea. And simplifying the things. It's just that I think Nabia and her team would be working with the customers to customize the forms, and some sort of security features will be built in so that these forms cannot be tampered. I'm sure that she would be considering this.
Yes, Mr. Aftab, that's a very good suggestion. And that is very important, of course, if I want to sell it out in UK, where GDPR and all concerns are there. So I have to build in a lot of security. I'll note it.
So Nonopa is asking, where do you see this in 5 years?
I really have much expectation from this company, and I think it will change the future. I think of making forms. I've heard that I have pitched this to some people before, and they told me that it is a game-changing idea.
It is. It's a very broad ranging, right? You're not, forms are everywhere, and frequently they're just very complex, and it's not efficient to print them out and fill them out and then scan them. I think you made that case. Okay, Marcus asking who you see as your competition.
Currently, I see document automation platforms like Automation Anywhere, and you might say Document also as my competitions, or my just pretty close to what they are currently doing. The only difference is that I am not like asking for the humans to put in their efforts. Rather, the technology is doing that part.
Sorry, can you repeat the last sentence? You're done.
Yeah. So I mean to say that my competitors are like Document and various other document automation platforms and Typeform and Automation Anywhere. But the only difference is that uh, while those platforms require us to work on those platforms and we have to be tech savvy, of course, to use them. But our platform would not require any efforts from the humans rather than simply uploading the form so that anyone can use it. So I don't think I have like made searches, but I did not find any competitor,
Mhm.
potential
What do you see
competitor.
as the biggest either technical or business challenge for this effort?
The technical challenge is actually a potential challenge, but I have seen over the past few years that technology makes a lot of things possible, and we are almost like close to figuring it out. But the business is a challenge on which I have to work because I'm just a fresher. I mean, I just graduated, and I do not know about the business industry a lot. That is a big challenge for me.
Okay. And do you have any sort of do you have a work? When do you think you have your first working prototype then?
I think by the end of this year, I'll try to develop it.
Mm-hmm. Okay. Well, great. Okay. If anyone else has a question, please please pipe up now. Otherwise, I want to thank you, Nabha. This is very cool. Thanks for sharing this with us. I think your forums are like I said, they're pretty much ubiquitous, and they are painful in around the world. And there's technology that makes it easier for non coders, to create those Q&A systems and to automate much of that process. I think that seems like a powerful idea. And there are definitely a lot of players in the document automation space. I think it probably makes sense to kind of try to delineate how you differentiate from them. Is it on simplicity, or is it on on price? I don't know. It's there's like a slew of document automation and expert system creation technologies out there. But maybe if you really focus in on the forms and have this, very advanced technology that can sort of extract all these entities from the forms, and without much need for human intervention, I think that could be really, really powerful. All right. Well, thank you so much for joining us. What time is it in India right now?
It's 2:19 a.m.
Oh my God. Really appreciate you you staying up so late.
Nabha, this is Susan. If you can stay up just a little bit longer, if you want to drop your email into the chat, that way people can contact you later if they like.
Yeah, sure. Thank you, Susan, and thank you.
Really,
thank you.
It was wonderful to have you. Thank you so much for joining us. And please drop your contact info in the chat. And then let's turn it over to Thibaut. Thibaut, are you there?
I am.
Hey.
Nice to see you.
Nice. Good to see you too.
Nice
background as always.
Yes, thank you.
And
it's my way of traveling.
Yeah, there you go. So yeah, we're excited. We learned about your project at the Future Law Conference. I think is what you sort of introduced it to, sort of a broader CodeX audience, and you've been very effective, I think, in getting this project off the ground and leading it and bringing in important stakeholders, and so I'm excited to get an update on where you are with the project, and also perhaps learning, what you think are some of the specific needs, and perhaps we can help you move the project along. So over to you.
Yes. Well, I'm very happy to be amongst you. You will see that, every time I get the opportunity to thank you, I am doing it, and I will be doing it today, because the project wouldn't exist without you, and CodeX, of course, but you especially. So I'm very grateful for that. I hope you can all see my screen right now. I was a bit conflicted when I prepared for tonight or today, depending on where you stand. Because I thought maybe some of you indeed were not at the Future Law conference. If so, you missed the best conference of the year, but that's okay. And so therefore I thought, well, maybe I can actually give you an overview in like 2 or 3 minutes of what is computational antitrust, which is the title and the subject of the project, and then move on to the updates. And of course, also I would like to give you some updates on the substance of what's happening, knowing that indeed it's very exciting. Everything that's happening, it's a bit crazy, but in a good sense for once. So to be very brief, the reason why we talk about all that in computational antitrust is for different reasons. Reason number one is that the detection rate of infringement to antitrust is very low. So it means that if you infringe antitrust or competition law, most likely you'll be fine. And this is not what we want for reasons that I don't have the time to explore today. And we actually, and I do think that it's about to get worse for only one reason, which is that the number of data generated all over the world is about to explode. 44 zettabytes of data produced last year. And as you can see, over 2,000 zettabytes of data produced in just 15 years. A zettabyte equals 1 trillion gigabytes. And already we produce more data than there are stars in the universe. And yet, as you can see on the screen, this is about to explode. So if you are an antitrust agencies and you are looking for infringements out there, trying to screen the market, you need to have the right tool. Otherwise, there is nothing you can do. The problem is that agencies don't have the means to be more proactive, although in the US, the FTC and the DOJ will get an increase in their budget. But most likely what they do is that they wait for companies to complain, which works. But of course we can improve, because 90% of the time they just wait for another company to come. But when comes the time to go out there and detect practices, they are not super active, because again, they don't know how to proceed and they don't have the means for that. So that's issue number one, detection. Issue number two is the one of, once you have detected the potential practice, how do you analyze the practice? I gave a few examples over here. The CMA, which is in the UK, the competition agency there, analyzed, had access to Google and Bing search queries for just 1 week, and they ended up with 3 to 4 billion of items to analyze. Of course, you could have lots of interns, but it won't do the trick. So for those reasons, it seems that we may want to have computational antitrust. Some agencies are not taking that road, but I think the more it goes, the more they are actually considering those solutions, as I'm about to explain. But what we see is that some antitrust scholars, if you're not too much involved in the field, are saying, well, you know what, this is true. It goes too fast, it's too complex. So, let's give up and rely on the market. Some others are saying, well, we should regulate ex ante and prohibit practices even before they are implemented. But even in that situation, as we know, ex ante regulation is not perfect. Some companies will infringe and you will need to detect that. So if we don't give up, we could choose computational antitrust. And of course, as you can imagine, this is my preferred solution. And I expect in a CodeX meeting that this is everyone's preferred solution. So I'm very happy about that. So this is the general idea. The question is now, if indeed we need to increase competition law or antitrust with computer science, because it would be Sherlock without Watson. The question is, which Watsons do we need? And here I just want to give you a brief overview. And here I will start being a bit more specific and mention some of the papers that we have been publishing within the project. So when it comes to anti-competitive practices, collusions, or monopolization in the US, here, as I said, number one issue is the one of detection. So you can imagine that you could develop, web scraping or other types of market screening tools, or develop APIs that will send data from companies to agencies and so forth. This is a solution. I'm actually working on trying to develop some of those solutions. You could analyze, of course, more documents. We do have some empirical work showing that the 10Ks, which is the financial form, one of the many financial forms that we just heard in the US, is actually valuable when it comes to detecting infringements to antitrust. So we could think that agencies could share documents and analyze the documents. The one place where we know we can start, because we know agencies do have the data, is actually to analyze their own case law. And to show you our relevance, I think this is actually today, the DG Comp, which is the European Commission, the antitrust division, actually said that they wanted to increase their retrospective analysis of their own case law. And actually, this is the first paper that we published within the project by two researchers from Italy and Belgium. And what they've done is that they actually train a machine learning algorithm, both supervised and unsupervised. They tried the two, using the decisions coming out of the FTC and the DOJ. Interestingly, it wasn't working because the case law of those two agencies is too different and the algorithm got confused. But if they only trained the algorithm using the FTC decisions, then they ended up with what I think is amazing results, detecting practices out there when it's actually invisible to the human eye. So this is something that all competition agencies can do, take their own case law and start there and try to train something on that basis. Number two, merger control. Here, we don't have the detectability issue, but we have another issue, which is that agencies, and the same is true all over the world, have no choice but to make a decision in a very short amount of time. And so for that reason, they may fear that they won't get all of the information from the companies, or that they will get wrong information, whether it is, on purpose or not. So just consider those two examples. Those are two press releases coming out of the European Commission. Long story short, what happens is that in one case, Facebook intentionally didn't send all of the information to the European Commission when acquiring WhatsApp. In another case, May 2021, a company forgot to provide the DG Comp with some of the relevant information. It seems to me that here blockchain could be a solution to be considered. You could imagine that companies will store their market shares on the private blockchain, and then will actually provide the European Commission or the FTC or any other competition agency with access to that blockchain. And of course, if they want to delete information before they notify the merger, this will be visible. So this could be valuable information for agencies. And I see no reason why we shouldn't be considered this solution. Something also, and that's paper number 3 that we published, is that when it comes to merger control, you may have heard about killer acquisitions. If that is not the case, you may have still heard about it without knowing that you heard about it. The idea is that the big tech companies will be acquiring startups, not for the sake of capturing the tech, but just for the sake of killing the startup before it actually competes with them. That is being called killer acquisitions. Agencies are struggling to identify those acquisitions because how can you know? And in a paper published 2 months ago, 3 researchers from the MIT actually said that a solution, and I very much believe that it could be a solution to be considered, is to analyze the technology, which surprisingly is something that we do not do in merger control. All that we care about is the turnover of the company and eventually the market shares, but we never study the technology being acquired, and they show how this could be taken into account, especially using computational tools. Number 3, the policies. Well, here you could, as I said already, do some retrospective analysis. You could also have a look at the future. And of course, as we know, prediction is hard, especially when it's about the future. But I still wanted to show you that this is not impossible to simulate the future. It's not perfect, it's a model, but it might be closer to reality than what we do today in competition law, which is to rely on the idea that the average consumer or the average person exists, which of course isn't true. So here I just wanted to show you those 2 way of simulating. This is called agent-based modeling. You may create some simulation in which you might say, well, if the price is up by a level of 10 points, I want the company to leave the market. And you may, of course, enter more criteria. what you may also be doing is to actually develop those agent-based modeling using AI and to give them some agency, hence the name agent-based modeling, and try to see what will be the effects of price increase or a competition law decisions, et cetera, et cetera. So those are a few of the solutions that we have been exploring in some of the papers that we published. But I thought now I will be very practical. So this is hosted on the CodeX website, our webpage, where, of course, you may access our publications, but also the list of all of the agencies and the people involved. So what we do, to be very concrete, is that we publish one academic article every month of about 10 to 15 pages, so that people really want to read the paper. We also publish a podcast episode in which we discuss with the authors of the papers. And the idea is to organize another workshop at the end of the year with all of the agencies part of the project, plus the people who wrote the paper and the advisory board. So when I say we, who is we? So this is an incredible team working on editing the paper and being in touch with everyone. And also the advisory board, Roland is part of it. I see Lance being in the room as well, and many others. So it's now quite a fantastic team once again. And so far, so good. We got the press release from the DOJ expressing their official support, but also some other agencies. You could see the Austrian competition agency, the Slovakian competition agency, Czechia, et cetera, et cetera. The New York Times covered the project already 2 times. So this is great. Of course, very grateful for that. Some agencies are already considering using computational tools, but I wanted to show you this, which I think is quite cool indeed. Those are all of the agencies which are part of the project. So we have 55 competition agencies. I hope that we can reach 60 by the end of the year. And the basic idea is that at the end of the year, they're all going to send us a 2-page document explaining which implementations of computational tools they are doing this year. And all of that, of course, will be published in open access so that everyone can access. I can tell you already that when we publish a paper, we send it to all of the agencies. And I receive email on a regular basis from, I won't give name, but asking very specific questions. And I believe that some of them are already implementing some of those solutions. So this is just an overview of the paper. I discussed a few. We published actually a paper this week about the Microsoft case. I find it also fascinating. They thought at the time of the Microsoft case in the US that they would need just less than 10 employees to implement the remedies, which consist in providing competitors with the documentation necessary for the interoperability of a Microsoft product with their product. They ended up with almost 1,000 employees. So they discussed in the paper how the DOJ was tackling the issue and how computational tools could help. So this is some of the questions. Of course, I'm very much aware that the idea that we can compute the entire world is far from being, something we can achieve. Maybe one day, I do not know. If you are into this kind of stuff, there is a nice TV show called Devs, in which they do have a quantum computer. But for now, this is not possible. And yet, if you consider this, this is weather forecast, and we know it's not perfect, and yet we very much, find it useful. And actually, some empirical studies is showing very clearly that our ability to forecast the weather is improving. It is way better now than it was 30 years ago. And this is a screenshot that I took from Groundhog Day. You may have seen this movie, but I very much believe that if we do not use computational tools in antitrust law, we will not learn from past cases, and we will be stuck, in living the same day over and over again. So at the end of the day, it is about matching the substance of dealing with the big tech companies more and more with the methods that competition agencies are using. And again, we do our best, and I'm very grateful for the support and very much looking forward to your questions and comments. And of course, if you are interested in a subject, please send me an email and we can have Zoom or emails or and anything you deem necessary. So thank you very much.
Cool, Thibaut. This is it's really exciting stuff that you're working on, and it's just amazing the amount of momentum and traction that you've been able to build in a short time. And so one of the things that I was wondering is that most of the tools you're talking about are sort of kind of directed at enforcers of competition law. You already mentioned at the beginning that in a way the competition authorities sometimes kind of rely on private parties to alert them to certain collusions and abuses of dominant power. Is there a way that possibly there might be legal tech innovators who work with private parties to identify competition, anti-competitive practices of their competitors, such as, in the IP space, we have, private entities private startups working with large tech companies to tell them if they should settle a case with an IP troll or not. And is that something that's also possible potentially?
So I never thought about it. I never heard of it. That said, we know that when there is a Google case or Amazon case, we know the other companies behind the case. So they are pushing for, the case to be adopted by the agency. But I've never heard of a company having a, dedicated team trying to detect infringement from their competitors. It may, I mean, I have no idea. I never worked for the big tech companies. So maybe some people in the room have more info.
Right.
But
I was just curious.
Yeah. But it might be that companies want to use those tools to detect their own infringements, because sometimes they do infringe competition law.
The compliance.
If I may, there is a joke in the field of competition law, so it's a bit of a geeky joke, but it's three guys in jail, and one is saying to the other, "Why are you here?" And he's saying, "Well, the prices of my product were too high, and I was saying, this is a way to exclude competitors." The other one say, "Well, my prices were too low, and this is predatory pricing." And the third say, "Well, my prices were the same as the prices of my competitors." So no matter what you do, you will go to jail, or you would infringe competition law one way or another. So it might be that companies want to use those tools to detect what they do without even knowing it. Of course, sometimes they know about it, but sometimes they don't. So it might be.
That's interesting. So as a sort of helping in compliance with competition laws. Yeah, that's very interesting too. So Rachel is saying, how would you look at future scoping, I guess, antitrust issues going forward? Surely there will be a need to account for problems that are not on anyone's radar until well after the facts.
Yeah. I hope I'm going to answer your question. So in that paper that I mentioned, the Mazzaroto E2 paper, what they've done is that they analyzed the FTC decision, and especially in the pharma sector, and they ended up finding, using machine learning, that when companies engage in one type of practice, they also always engage in another type of anti-competitive practice, which wasn't seen by agencies. So indeed, you may be able to detect things which are not, out there or on the radar of agency. That's especially if you are using unsupervised machine learning, what you are not telling your algorithm the type of data you want as an output. So I hope I answer your question, but if not, please send me an email.
So Dasa is sending you kudos. He says computational trust is a perfect fit for computational law generally. I very much agree with that. Thanks, Dasa. And I don't know, Mark, what are you referring to? Mark is saying we have an application for that. I'm not sure especially exactly what you're referring to. Maybe you can clarify. And Nanopa is saying brilliant. So how can states adopt blockchain antitrust? What obstacles lie ahead for this to happen?
Sure, yeah. And Daza is also part of the advisory board. I didn't see that, Daza, you were in the room. For the states, it might be that if they want to use data coming from other agencies, I'm not too aware of what's happening in the US in that regard, but in Europe, it will be complex. Agencies can't do that. So you will need to change the law to be actually, enable the technology. But if you are just talking about an agency trying to develop a blockchain on their own to deal with, it seems to me that merger control is the place where you want to start, because if you work in the field, what you would do is that you will print 300 pages, you will send an intern to the agency to actually give that piece of paper, and that's the way it works. For the last 40 years, it hasn't been improved. So it seems to me that using blockchain as a register that you can trust, smart contract to automate all that is something that agencies could do. For now, I can see that there is a lack of expertise. and I receive, again, lots of questions from those agencies, but they are very interested. I mean, the reason why this project is bringing me so much joy is that when I see the reaction from agencies and companies, everyone wants to engage in that. So it's a matter of expertise, but I think we are going in the right direction. So I'm happy to report that, actually.
Yeah, great. Well, and then maybe the last question, because it's already time. Faith is asking whether this can be adopted in any jurisdiction.
I mean, I'm not sure what you are referring to with this, but again, it seems so far that the UK is the leader. They do have a team of over 50 computer scientists working for the competition agency. But the FTC is doing something quite cool. They use a tool called Relativity that will actually go out there and scan documents and try to detect cartels, even though the word cartel or collusion will not appear. So all of the agencies are racing, they are cooperating, and that's also one of the goals of the project, which is to put agencies in touch, and then we'll see what happens. So yes, the answer is positive again. They can adopt that.
I think the other example you gave at the beginning was also interesting in terms of doing the machine learning project at the FTC level and trying to, where they identified, certain practices that they weren't really aware of before in their own case law. So so I think that's very exciting too. Well, thank you so much, Thibaut, for the update. It's a great project, and I really appreciate the update. And I feel like this is I'm sort of getting a glimpse at the future of antitrust, and it's great to have you really spearhead this effort, and we're excited to be part of it.
Well,
thank you so much.
Yeah, thank you very
Thibaut.
much.
All right, then over to Mitch. Mitch, are you there?
I am, Roland. Hi.
Hey, Mitch.
Good to see you. Can you see me?
Yes.
All right. Yeah, it's been too long. I so appreciate you having me here and getting to see all the great things that everyone has going on. Can everyone see the screen right now?
Yes. Perfect.
Wonderful. Well, as Roland mentioned, I've been a fan of CodeX for a long time. I actually was thinking about it. I believe I attended the first Future Law conference back in 2013, I think was when it was. So attending Future Law this year, I just have to say, seeing the conversations around computable contracts, how far things have come, it's exciting to be here. And I also hope that what I have to share is pretty exciting to this group, as we're also applying a lot of those same concepts at InCloud Council today. So really excited to share and get folks' thoughts. Quick background on me. I'm an attorney. I'm licensed to practice law in the state of California. But before law school, I studied symbolic systems here at Stanford, which for those of you who might not know is a mix of computer science, logic, linguistics, and artificial intelligence. I just loved it. Shortly after starting to practice law, though, I realized that technology was my passion and that I wanted to work on the system instead of in the system. So I joined what was at the time a relatively small startup called Doximity and helped it scale to a leading physician network, and eventually led the mobile platform and data products, including a number of machine learning initiatives. Then about a year and a half ago, I was introduced to InCloud Council and saw the product and the market fit and the people, and just jumped at the opportunity to apply both my passions for technology and my passion for law with an incredible team. So I just do want to say it is all about the team. When I joined, InCloud Council was profitable, and then we raised over $30 million from Battery Ventures, and it's been going full speed, scaling across the company in a number of functions, but on the R&D side in particular, in product design, front-end engineering, data infrastructure, machine learning, and others. So really, I want to say to the folks here, if you love legal technology and know good people, we want to talk to them. So please do send them our way. So what do? We are a full service, purpose-built solution for negotiating and managing routine contracts like NDAs, joinders, non-reliance letters, and more. And while these contracts require legal review, we can leverage technology, processes, and data to augment our lawyer network. And we do that to achieve our goals, namely our goals of lowering costs and reducing the turnaround times on these documents for our customers, in addition to unlocking the data-driven insights that, as we know, are currently often buried in file cabinets somewhere in someone's office. And so we look at this as a real win-win-win. Yeah, some exciting developments. So how are we doing so far? Well, with over 400,000 NDAs successfully negotiated on the platform and more every day, and a 200+ strong attorney network, we can confidently say that we know more about NDAs than anyone else by a large margin. I'm not sure that many people would brag about that, but we love these routine documents, and we like knowing everything we can about them. So to talk in more concrete terms about our products, what you see here is a document lifecycle, and this is our main product focus. Starting with a document being allocated to our attorney network, it is negotiated, executed, and summarized, which we call our core document processing product. We also have a SaaS solution that takes those documents, extracts the salient terms, and then allows for the tracking of those terms, the obligations to stakeholders and compliance, and the tasks required to complete those terms for reporting purposes, and we call that insight. But what I think is most exciting for this group, and where I want to focus in particular, is the summarization step. Let's go ahead and see if everyone can see this here. Great. So on the left, you can see the high-level structure of the terms of an NDA. And on the right, you can see the NDA itself, along with our machine learning prediction highlights. And as you can see, this allows our lawyers to jump to relevant clauses quickly, and then even extract those predictions, those suggestions for the lawyers to adopt in a single click. But again, the part that I love is that these predictions, whether accepted or not, feed back into the machine learning system that powers them. So in this system, it's a human in the loop system. It's ever improving, and it's a virtuous cycle based on this ever expanding set as our lawyers produce it of expert labeled data. But what's more than just the system and the feedback loop from our attorneys is what's under the hood and the structure of the data itself. Now, recently at Future Law, I loved the panel on computable contracts, where the panel spoke to the point that in computable contracts, the limiting factor is less about the ability to compute and more about the availability of a domain-specific language that can provide the context and meaning to compute upon. So in that case, I believe the panel's example was the shipping container that was blocking the Suez Canal, and the idea of how to model that in conjunction with the contracts that the blocking of the canal might affect. But the concept of a domain-specific language is one that we at In Cloud Counsel have also taken very seriously as we've developed our capabilities. And what you see here on the right is an early version of our proprietary anatomy, which is a hierarchical set of terms based on our over 400,000 NDAs that forms a domain-specific language for NDAs and a scalable framework to tackle other routine contracts. And as you can see, for example, here, confidential information can have carve-outs or be shared. And if shared, there's a list of possible entities with whom it can be shared. But the part I love is that this hierarchical set of terms not only allows the hierarchy itself to encode information, but it also, we found, supercharges both our machine learning capabilities as well as our data analytics. So for example, as I'm sure many of you know, most AI contract platforms train on a set of clauses and approach machine learning as a shallow, relatively simple matching problem. But in our case, the NDA anatomy creates a hierarchy that allows for depth and helps identify relevant provisions with more accuracy by leveraging this additional granularity. In addition, what you see here on the left is a sampling of 20 terms that we're identifying with our models. But when broken down at this granular level, we can then abstract the models from a particular term or clause and instead look at the data types, such as the date, the entity, the duration, or the presence of a clause like a non-solicit or a non-compete. This allows us to scale the modeling efforts more quickly and with greater flexibility so that we can really invest more deeply in fewer models with wider applicability. Really just the benefit of trying to do more with less, which as we know is a key to scale. And in addition to better modeling, I mentioned the anatomy also allows for greater granularity of insights, which you can see can get down into the specifics within a clause, not just whether the provision itself exists. And in addition, we take this data along with the data that we have on the end-to-end negotiations, the turnaround time from the start of the negotiation to execution, and it allows us to identify specific terms and their effect on the length of negotiations. So our customers who want to get the NDA signed so that they can get the deal done, we have a number of firms and private equity firms that view these NDAs as a hurdle to their business objectives. We can really give them a data-driven understanding of the trade-offs between the terms and positions to help them better achieve their objectives. The other exciting piece is that this proprietary anatomy not only allows for the summary snapshot at the end of the negotiation, but it also allows us to build a digital playbook of our customers' preferred fallback and final negotiating positions on this unified framework, this domain-specific language. So what you see here is a graphical example of a playbook built on the anatomy. You can note how this fictional customer prefers not to have a delayed disclosure clause if you're squinting really closely, but will fall back to agreeing to one. You can similarly see the preferred and fallback positions for representatives, that they might start asking for liability for breach for any provision of one of their representatives, but would fall back to an applicable provision. Really just paired with the anatomy, this not only allows us to better detect clauses and terms, but it also allows us to compare those terms to a customer's playbook to highlight deviations and further augment the lawyers as they negotiate these NDAs on our platform. Now, this is a capability we're currently productizing, but we couldn't be more excited for the potential of this unified framework of a domain-specific language and a digital playbook to help in identifying those customer positions and augmenting our attorney network. And last but not least is what I alluded to before, which is the human in the loop component of the system, in which we both serve predictions to our lawyers and then leverage their responses, either the response accepting the suggestion or entering a different value to feed back into those models in a virtuous cycle. When I think about this, I think about Google and Bing, and the fact that Bing may in fact have a better algorithm than Google. But with all of us on Google clicking on the second or fourth or fifth link, they have our feedback to feed back into their models in a way that Bing does not and makes Google impossible to catch. So similarly, with this volume of NDAs and more every day, we're seeing a similar effect where the speed and the accuracy of the predictive capabilities we're developing just continues to compound. And it's pretty exciting. For us, the goal remains leveraging these tools to increase lawyer efficiency and accuracy as we work to augment them in their practice and pass that value on to them and of course to our customers. I personally could not be more grateful to you all who continue to push legal technology and this whole idea of computable contracts forward. As Roland says, seeing how this has developed over the years and hearing those discussions is just integral to the development of these tools and technologies. So just want to say thank you for having me. It's truly an honor to be with you today talking about computable contracts. It really is a dream. And again, we're hiring, so please do let folks know, and I can stick around for questions if we do have time.
Cool. Thank you, Mitch. This is very exciting. So what's your target customer? Is it big tech companies that exchange a lot of NDAs, or the whole world?
Currently where we found the greatest need was in private equity firms. So funds that had hundreds of millions, billions of dollars doing these transactions where days mattered. They needed to be the one to check out the company and be able to have a conversation. They were just flooded with these NDAs that would delay them and tie up their legal departments. So they were our first customers, and now we're moving into real estate, healthcare. Really, there's a lot of folks who have them, and there's a lot of routine contracts beyond just NDAs that hit that sweet spot.
And what terms are the most negotiated ones?
Yeah, it's interesting. Non-solicits are big, and it all depends on the directionality of it as well, whether or not you're on the buy side of one of these or whether or not you're on the sell side. So a lot of it, as we know, comes down to leverage. It's one of the reasons why we believe in augmentation, not necessarily automation, because at the end of the day, some of these parties, it really depends on how much they want to flex on these provisions. But I would say non-competes, non-solicits are pretty big.
Yeah, that's a question that I asked myself before too when you gave your presentation. In my experience, NDAs are sometimes not, there's not very much flexibility on some on when you negotiate. It's sort of take it or leave it. But there must be a certain amount of flexibility for parties to adjust terms.
Yeah,
like that.
and Roland, just to let you know, one of the things that we are doing is in some of the private equity, we do have customers on both sides of the negotiation, obviously represented by their own counsel. But when we have these digital playbooks on both sides, we actually have been doing some research into the acceptable overlap and the tilt that goes into that to help speed up and augment those negotiations, finding those sweet spots.
And what sort of, it's interesting because I know that a lot of kind of contract automation projects have started to focus on NDAs just because there's so many, right? And ubiquitous. But I presume you don't want to stop there. And what do you see as sort of, what's the adjacent kind of type of contracts you think where you can leverage everything you learned about the NDAs and hit the road running?
Yeah, the way I look at it is there are certain types of legal forms that are so formulaic as to be commodities. And I think LegalZoom has a pretty good corner on that market. And then there are others that I don't think will ever be computed because they're just on the bleeding edge, finance and tax and other folks that are playing that cat and mouse game. I think NDAs are right in that sweet spot. Joinders are tangential. Non-reliance letters are others that we're looking at in addition to transaction documents, and really just building out the capabilities, not just for those documents themselves, but the other product I mentioned can handle even more complex documents as well and track those ongoing obligations. So we just look at it as the whole document lifecycle, but in terms of the routine contracts, non-reliance letters, I think is another big one that we're looking at.
Neat. And Daza is asking, does the universal NDA project adequately handle the need for rapid NDA agreement? If not, what's missing? Are you familiar with the universal NDA?
Yeah,
project?
the One NDA project. They just came out with something as well. And we applaud all of this. We want there to be less friction in the market. Those, I believe, are more less commercial transactions. We're dealing with a lot of big funding, and I think the nuance, even NDAs is a spectrum. So I would say I really hope that One NDA project can help with all those small businesses that really face that hurdle. But right now we're looking at the higher end of that NDA market. So we welcome any efforts to standardize and smooth the process.
Cool. All right. And where are you at as a company at the moment? You said you're looking to hire.
Yeah.
Give us are you sort of like, are you VC funded, or how big is your team?
In 2019, so the company was profitable for 6 years, and in 2019, Battery Ventures invested over $30 million, led that funding round, and we have taken our company from when I joined at 39 to, I believe the number is it's over 160 in less than 18 months. So wow. we're going, we're scaling and looking for good people, and expanding into APAC and Europe, where we already have a number of customers, and really going global. So yes, if you know good people, sales, marketing, account management, R&D, we would love to chat with them.
Cool.
Mitch, this is Susan. Be sure to drop your email into the chat.
Yeah.
Oh, great. I'll do that right now. And please, anyone listening, also feel free to connect with me on LinkedIn. Always love talking shop.
All right. Well, Mitch, this has been great. This is very, very exciting too. And as you know, this is a focus area for our center, computable contracts. This is an interesting approach that you're taking and cutting edge, and you seem to have a lot of momentum in that space. So congratulations, and it's great to see you again. I hope we can connect in person sometime soon.
And any research projects as well, please do let us know. We are very interested to partner and push that forward as well.
Cool. Fantastic. Well, wonderful. Thank you, Mitch. Thank you, Nabia, and thank you, Thibaut, for all of your great presentations and the important work that you're doing for legal innovation. Thank you all for joining us for this CodeX group meeting. Susan, can you give us a preview when we're meeting next already? Or
yeah, so we wish everybody a great summer. We'll be back towards the end of August, so stay tuned. And you never know.
Yeah, thanks for staying with us through this academic year. And it's a wonderful community we have, and we love those conversations we have almost on a weekly basis through the academic year, and really appreciate all of you and all the great work you're doing, and look forward to seeing you soon. Be in touch.